Legal Services in Philadelphia, and we have had a grant for the last several months funded by the CARES Act to do advocacy on behalf of nursing home residents during the COVID era. And so we've done a number of webinars for different audiences, including legal services and other attorneys, and we wanted to do one for ombudsman as well, because your work is so important. You're the ones who are really working directly with nursing home residents. And so I'm going to present this information today about residents' rights generally and in the era of COVID. And then we would really like to take questions and also to hear from you about what you are seeing, what kinds of problems you're seeing and issues around residents' rights and other issues right now, especially connected to COVID. So thank you very much for coming today. Okay, you want to advance to the next screen, the next slide, Alyssa? Okay, so we're going to start out by doing an overview of what we're going to be doing today. We're going to cover, first of all, just a review of residents' rights. We'll go through that fairly rapidly since it's going to be familiar to people, but it'll set some context for what we're going to talk about then when we talk about how COVID-19 and the policies in response to COVID-19 have impacted residents and their rights. We'll also talk about issues that we've been seeing. We'd like to hear from you about issues that you've been seeing, and we'll talk about how to advocate on behalf of residents during the COVID-19 pandemic. Next screen. So we'll start with a residents' rights review. All right, so and next screen. So we're on slide 4. So to begin with, really foundational, important right. Residents have the right to be treated with dignity and respect. And this means that residents have the right to be treated well in nursing facilities with kindness and with dignity, and with recognition of their importance as a human being and as an individual with their own history, their own beliefs and values and preferences. This includes honoring the choices made by residents and for residents getting to decide about choices about their lives, including choices about their schedule, including the right to decide when they want to go to bed, when they want to get up in the morning and eat meals and shower and decide and to decide what to wear and when to get dressed, as well as about what activities they want to participate in and at what time. This also includes the right to have and use personal belongings to the extent possible, which might include items that they bring with them from home, like pictures or decorations, or possibly even some furniture, depending on the space in their room. And having the facility keep the residents' property safe from loss or theft. It also includes living in a safe and clean environment that promotes their dignity. Residents also have the right to make decisions about things that are meaningful to them, and those choices are to be respected. Next slide. Residents also, very importantly, have the right to self-determination, and this has a number of different facets. Self-determination includes having choices and making decisions about aspects of our lives that are important and meaningful to us. As I was noting before, residents have the right to choose such things as what their daily schedule should look like, when to get up, when to go to bed, what activities to participate in, and how they spend their time, including whether they attend religious services and where. It means having control over your own life. The facility is required to accommodate the residents' needs and preferences. Residents also have the right to make decisions about their care. And that includes participating in the development of their person-centered care plan, which we'll talk about in just a minute. Residents also have the right to refuse or to request treatment. In addition to making choices about their care, residents also have the right to choose their healthcare providers, including their own personal physician and other medical professionals. Residents have the right to meet with resident and family groups, which are usually called resident or family councils. A nursing home is required to provide a resident or family council, a private place to meet in the facility, and to designate a staff person to provide assistance if it's needed. Councils are really important. They serve numerous important purposes. They can raise concerns or complaints that an individual resident may not feel comfortable raising by themselves. They can also be a forum for discussion and learning, and they can provide important input or suggestions to the administration or staff on how to improve care and quality of life. Choice and self-determination also come into play in other aspects of the resident's life. For example, he or she can decide to maintain control in managing their personal affairs and finances, including paying their own bills. Or they can designate someone to do it on their own behalf. If the resident asks the nursing home to hold their funds, the nursing home is required to keep the money in a separate account and provide a regular accounting of how much is available. Next slide. So residents have just as residents have choices and can make decisions about their lives and care, under the revised federal regulations, they have the right to be an active participant in the development of their plan of care. So residents have the right to person-centered care planning and person-centered services. The resident's person-centered care plan must be developed with the resident and with their interdisciplinary team of chosen participants. This is completed after the facility has completed an assessment of the resident's needs and preferences, and the care plan, the person-centered care plan, reflects how care should be delivered in accordance with those needs and preferences. In general, a baseline care plan must be developed within 48 hours of admission, and a comprehensive care plan must be developed within 7 days. So what's person-centered care? That means that the residents and their representatives, if they want to have a representative involved or if they need one, are informed and involved and in control. The facility, the person-centered care means there's a focus on the resident as the locus of control, and that the resident is supported in making their own decisions and having control over their own daily lives. So the resident should really be an active participant, and their goals and concerns should be addressed in this care planning process. Just as it sounds, the plan of care involves deciding what care and services a resident will receive to help them reach their goals. And it's created by the resident and staff together. When the resident enters the nursing home, the staff conduct an assessment that collects information about the resident's needs. What ADLs do they need help with? Do they use a walker or a wheelchair? Do they need a special diet or rehabilitative services? What was their life like before coming to the nursing home? Then the staff, along with the resident and any other person the resident chooses, should review the assessment, discuss the resident's goals, and decide on the plan of care that'll help the resident meet those goals. The development of the plan revolves around the resident's goals and preferences, and they are supposed to be at the center of decision-making. And that's an important principle for achieving quality care and quality of life in a nursing facility. Under the person-centered care requirement, when the person enters the nursing home, a baseline care plan must be developed and implemented within 48 hours of admission. It has to include initial goals, MD orders, dietary orders, therapy services, social services, and the PASSAR screening. And then within 7 days of the assessment, the nursing facility must do within 7 days of admission, the facility is required to do a comprehensive care plan developed by the interdisciplinary team. That team includes, what the regulations say is, to the extent practicable, the participation of the resident and the resident's representatives. And this is a really important area for advocacy. Residents sometimes, and their family members sometimes get left out of this process. The facility is required to make very active efforts to make sure that the resident and their representative are involved, including accommodating the representative's schedule so that they can be involved. The regulations state that an explanation must be included in the resident's medical record if the participation of the resident and the resident representative is determined not practicable for the development of the care plan. So if the person's not going to be included, a reason for that has to be documented in the person's record. The interdisciplinary team is also supposed to include the attending doctor, the RN with responsibility for the resident, CNA with responsibility for the resident, a member of the food and nutrition staff, and other appropriate staff based on the resident's need or is required by the resident, requested by the resident. So if someone who has a lot of therapy needs, it would be appropriate to have someone from the therapy department there. Or if they have other specialized needs, um, uh, a medical professional who handles that area should be there. Next slide. Nursing home residents also have the right to privacy. This includes privacy during treatment and when being provided with personal care. It means, for instance, that staff and visitors should knock on the person's door and wait for them to answer before entering. And they should ask if it's okay to come into their rooms. It also means pulling the curtains closed and shutting the door to the hallway when personal care is being given or when the person is getting dressed. The right to privacy also includes privacy in communication or contact with others, both in-person communications and on the phone, such as with a doctor or a medical professional when they have a call about the care, or if they're talking to an attorney or the ombudsman. It also means that in conversations and visits with family and friends, they have the right to have those visits be in private. And that includes a resident's communication with others, like the ombudsman, clergy, or their attorney. The right to privacy extends to communications between staff and visitors, and it also means that that their right to privacy should be respected by not sharing information about the resident's health condition with anyone. It involves any communication that the resident would like to have be kept in private. So it includes privacy in financial affairs and medical affairs, and information shouldn't be shared with others in the nursing home or others, even family members, without the resident's consent or unless they have legal authority, such as a guardian or a legal representative. And that includes access to the resident's medical records and also about the resident's finances. Next slide. Neglect, exploitation, and misappropriation of property. Abuse can take a number of forms. It can be abuse or bullying. And nursing homes are required to protect residents. And if there are concerns that a resident's been abused, there are requirements about reporting those concerns to the proper authorities. The facility must take steps to safeguard the resident's money and belongings as much as possible. The right to be free from all of these forms of abuse applies regardless of who might be the cause of the abuse, whether the perpetrator is a staff person, a friend, a family member, or even another resident. All residents have the right to be free from abuse and to receive help if they're victimized. Nursing home residents also have the right to be free from neglect. Neglect occurs when there's a failure to provide the care and services the person requires, whether that's food or hydration or help with hygiene, or the care that is needed to prevent the formation of pressure ulcers. Residents have the right to receive quality care and services that meet their needs as defined by their plan of care. Abuse also includes exploitation and misappropriation of property, which unfortunately happens all too often in nursing facilities. Next slide. Residents have the right to be free from restraints, and that includes physical restraints, mechanical restraints, or chemical restraints or drugs, which are used as a restraint. And it also includes the right to be free from any kind of bodily punishment or involuntary seclusion, like being locked in a room or isolated in a room, and any physical or chemical restraint not required to treat medical symptoms. So that means, of course, that a nursing home can't physically restrain a resident by holding them down, by tying them down. But facilities should also not use bed rails or recliners or chairs from which a resident can't exit for the purpose of preventing their free movement. A chemical restraint is the use of a medication when it's not used for treatment of a diagnosis, but rather to control behavior when it's not clinically needed. To to change their mood or to cause them to be more subdued or lethargic or easier to control or to reduce behaviors that a nursing home might find problematic. There are limited instances where restraints may be permissible. For physical restraints, pretty much not at all anymore. Chemical restraints are more of an issue, but again, can't be used unless they're needed to treat clinical symptoms of a diagnosed illness, and they cannot be used for the discipline or convenience of staff. And the reason for this is that restraints have been have been shown to cause other very, very serious problems that prevent the resident from having quality of life, and it can result in serious harm to their health. In order to use any kind of restraints, the nursing home has to have the residents or the resident representative's consent, and they must use the least restrictive alternative for the smallest amount of time, and they have to document that they've evaluated whether the use of restraints continues to be needed. So for instance, antipsychotic medications can only be used to treat an underlying medical condition, and only after all reasonable attempts have been made to address the issue with the doctor's approval. Next slide. Residents also have the right to be fully informed about care, changes to their health status or their care plan, or any changes to their rights. And they have the right to be fully informed about this in a language and in a manner that they understand. So this includes residents must be informed about the kind of care that they're receiving, including any risks or benefits, so that they can make decisions about that. They also have to be informed about any changes to their health status or to their care plan. Although, of course, care plans should be only getting changed with the participation of the resident in a person-centered care planning meeting. Too often, healthcare providers will talk to family members or representatives and not the residents themselves about changes in condition or the plan of care. But unless the resident has designated another person to receive that information, or unless they've been determined to be incapacitated by a court, the resident has the right to receive this information and to participate in decision making. Residents also have the right to be fully informed about their rights, which must be provided in writing to the resident and also posted in the facility. Residents also have the right to full information about where they can get help if they need it, which means the facility is required to provide contact information for the ombudsman program, as well as the state survey agency, which in our state is the Department of Health, which oversees and licenses nursing facilities for compliance with federal and state regulations. Next slide. Residents have certain rights to be protected during the admissions process. For instance, an admissions agreement can't conflict with federal nursing facility law. This was recently added because admissions agreements were found to sometimes conflict with relevant law. So an admissions contract can have provisions in it that are prohibited by federal law. The admission agreement also can't waive protections or requirements that are in federal, state, or local law. They can't waive the right to receive coverage under Medicare and Medicaid, and they can't waive the facility's responsibility for the resident's personal property. Applicants also have certain protections. Unfortunately, nursing homes don't have to accept all applicants. But they do have to comply with civil rights laws, which say that they can't discriminate based on race, color, national origin, disability, age, or religion. Facilities are also not allowed to require or to request third-party guarantees. Third-party guarantee is where a person is asked to take on financial liability for a nursing home resident's bill. And it's been very common for nursing facilities to try to get family members or even other people to sign admission contracts and to sign provisions that would make that third party liable for the bill in the event that Medicaid doesn't pay or the resident doesn't pay. And we have seen, and we continue actually frequently to see people, family members getting sued for nursing home bills. However, federal law prohibits facilities from requiring as a condition of admission, or even now requesting third parties to guarantee payment for a nursing home resident. The 2016 revised federal regulations, as I said, prohibit a facility from requiring or requesting this. However, there is an exception. The facility may request and require a resident representative who has legal access to a resident's income or resources which are available to pay for care. They can request or require that person to sign a contract to provide facility payment from the resident's income or resources, but it must be without the resident representative incurring personal financial liability themselves. So in other words, the facility can ask the person to sign an agreement where they have access to the resident's funds, which are available to pay for the nursing home care. They can ask them to sign an agreement saying that they will make those funds available to pay for the bill, but they cannot make the person, the third party, personally liable from their own funds for the nursing home residence bill. In addition, regulations about the admissions process require that facilities must disclose if the facility has any special characteristics or if they have any service limitations. If there are particular services they don't provide, they've got to notify the potential resident about that at the time that they are being admitted. If they don't disclose those limitations, that can be cited if a facility subsequently claims that it can't meet the resident's needs. Next slide. Residents also have the right to be free from discrimination. Residents have the right to be free from discrimination on the basis of race, gender, creed, or color, or in violation of the Pennsylvania Human Rights Act and federal civil rights laws. Okay, residents have the right to have visitors. So this is something we'll talk about what the federal regulations say, and then in a little bit we'll talk about how this has been very much altered during the COVID epidemic. So what the federal regulations say is that the resident has the right to immediate access to visits by relatives or non-family visitors. Non-family visitation, however, is subject to reasonable clinical and safety restrictions. So a facility has to meet these requirements. They have to inform each resident or the resident's representative, if they have one, of their visitation rights and the facility's policies and procedures about visitation, including any limitation on those rights, the reasons for the restriction, who they apply to when they're informed of their rights. They also have to inform the resident of their right to receive visitors they designate, including, but not limited to, their spouse. And that is defined to include a same-sex spouse or a domestic partner, including a same-sex domestic partner, or another family member or a friend. They also have to inform the resident that they have the right to withdraw or deny such consent at any time. So if the person decides they don't want to have someone visit, they have the right to withdraw the consent for that person to visit too. Facilities are not allowed to restrict or limit in any way visitation privileges on the basis of race, color, national origin, religion, sex, gender identity, sexual orientation, or disability. And they're required to make sure that all visitors ensure full and equal visitation privileges. So we'll talk about how that's different right now. Residents also have rights around transfer and discharge. So just very quickly, nursing facilities are not allowed to involuntarily discharge residents except for six permissible reasons, which are listed here, where it's necessary for the resident's welfare, where the facility can't meet the resident's needs, if the person's health is improved sufficiently that they no longer need nursing home level care, if the safety of other people in the facility, other people in the facility would be endangered by the resident, or the health of individuals in the facility would be endangered, if the resident has failed to pay or to have paid under Medicaid or Medicare after reasonable and appropriate notice, or if the facility ceases to operate. So these are the only reasons a nursing home can involuntarily discharge someone. They can't discharge them for other reasons, like their failure to follow rules, or needing too much care, or being difficult or demanding, or having a mental illness that may make them more challenging to serve. None of these are permissible reasons to discharge a resident. Only these 6 reasons are. If a nursing facility wants to involuntarily discharge a resident, they must be given at least a written notice, at least 30 days in advance in most cases. And the facility has to send a copy of that notice to the long-term care ombudsman program. They send it to the state program, which in turn should be sending it to the local long-term care ombudsman program, so that local ombudsmen are aware of these discharges and can get involved and assist where needed. The notice has to have one of these 6 acceptable reasons, and it has to include the effective date of the discharge, the location to which the person will be discharged, which has to be a place which is capable of meeting their needs, and information about how to appeal the nursing home's decision. Before a resident's discharged, the nursing home has to provide them with a safe discharge with sufficient preparation and orientation so that it's a safe and orderly discharge. And again, it has to be to a location that can meet their needs. Residents have the right to appeal a discharge like that. And I would just encourage ombudsman programs which are seeing discharges like that to reach out to your local legal services programs to see if they can assist with that. I think that we handle those appeals at my program at Community Legal Services, and I know that there are some other legal services programs around the state that also do. I think that there are a lot of programs that are legal services programs that are less familiar with those cases, but I think it's partly because people don't really come to them with those cases. And if residents or residents' families or the ombudsman reached out to those programs, they might be able to obtain legal representation in discharge hearings for those residents. Residents also have the right to return to the nursing facility after a hospitalization. If they're sent to the hospital, they have the right to go back to the nursing home, to their bed, or to the first available bed if their specific bed is no longer available after the bed hold period. And that means that that the transfer discharge rights in federal nursing home regulations protect against hospital dumping. The facility can't just send the person to a hospital and tell them that they can't come back. If so, that's an involuntary discharge, which can be appealed. It can be reported to the Department of Health as well. There also are some rights with regard to moves within a facility. Residents must be given written notice if a facility wants to change someone's room. The facility has to give the resident written notice with the reason for the change before a change in room or roommate. And the resident can refuse in certain circumstances. Namely, they can refuse to change rooms if the purpose is to move the person out of a Medicare certified room, or if it's solely for the convenience of staff. Next slide. As I was saying, residents have the right to appeal an involuntary transfer or discharge. And this lists some of the rights that, that residents have in an appeal like that. They have the right to examine any files or documents or records that are going to be used at the hearing. So that's going to be a lot of the records kept by the nursing home, like their assessments, care plans, documents like that. They have the right to be represented by a person they choose. They don't have a right, I mean, if they can get an attorney, they can have an attorney, but they don't have the right to have an attorney appointed, unfortunately. They have the right to bring witnesses to the hearing, to question and cross-examine the nursing home's witnesses, and to present their own argument about why they should not be discharged. And they have the right, although these hearings are normally held by telephone, they do have the right to an in-person hearing if they want one. Next slide. This is a really important right, the right to receive services with reasonable accommodations for their needs and preferences. And so this is the right to, a nursing facility is the resident's home. And just as we all have the right to make decisions in our homes about how we're going to spend our time, nursing home residents have the right to have their preferences where they're reasonable and can be accommodated, to have those preferences accommodated in a nursing home. The exception being when to do so would endanger the health or safety of the resident or other residents. Next slide. And finally, residents have the right to raise grievances. Residents can complain if they're unhappy with the care or something else in the nursing home, or if their rights are being violated, and they must be allowed to do so without retaliation from the facility or its staff. If a resident files a grievance, first of all, each nursing facility is required to have someone who accepts grievances, and the facility is required, if they receive a grievance, to take steps to resolve that complaint or grievances and to keep the resident informed about what steps were taken. The resident also has the right, of course, to go to the long-term care ombudsman as a resource or to file a complaint with the ombudsman about the care they received, life in the facility, or concern about violation of their rights. Residents are often concerned about retaliation. So it's important to know that there are strict federal and state laws prohibiting any retaliation against residents for voicing grievances, including for reporting abuse, neglect, or exploitation. All right, next slide. All right, so having talked about the rights that we're all accustomed to, let's talk now about the impact that COVID-19 has had on life in nursing homes and on these rights. During the past 8 months, the federal government, CMS, and the State Department of Health have taken multiple steps in response to COVID-19. We're going to focus on the ones that impact residents' rights. Next slide. So just generally, let's talk a little bit about the federal response from CMS, Centers for Medicare and Medicaid Services, to COVID-19. First of all, there have been, of course, significant restrictions on visitation by people outside the facility coming into the facility to see residents, and also restrictions on access available to long-term care ombudsmen and even Department of Health surveyors, of course, for the reason of trying to prevent the virus from being brought into facilities. In March, CMS imposed a blanket restriction on visitation, essentially prohibiting almost all visitation by families and other loved ones to residents of nursing facilities. It also, while it didn't prohibit ombudsmen and surveyors from coming in, it significantly restricted their access to come into nursing facilities and encouraged those interactions to happen instead virtually or by telephone. And we're going to talk about that in some detail. I'm just going to start out by going over the different areas that we're going to talk about. There have also been changes to transfer and discharge rights. And specifically, facilities are allowed to transfer residents to another facility or to move them within the facility for cohorting purposes. Cohorting, we'll talk about cohorting being the separation of different residents for the purposes of preventing infection from spreading between people who have been exposed or who have COVID from people who have not been exposed and don't have COVID. And these transfers are permitted without the usual notice and appeal rights. And we'll talk about what those changes have been. The federal government waived a number of federal regulations in March in order to address the COVID-19 crisis. One of those waivers was a waiver of some of the physical plant requirements to allow nursing facilities to create temporary new rooms in a nursing facility in order to make it possible to cohort people more effectively, to move people, to separate people who are exposed from people who are not. And so it allows them to create new rooms for people out of common rooms that normally would never be used as bedrooms, like dining rooms or common areas, or even to use buildings that are not certified as a skilled nursing facility, to allow them to be temporarily certified if they're needed, to allow residents to be isolated in a way that's not feasible in the existing nursing facility building. The CMS also waived training requirements for new nurse aides. It waives the requirement that nursing facilities not employ anyone for longer than 4 months unless they meet the training and certification requirements in the federal regulations. So this was done in anticipation of staffing shortages, which indeed there have been. So whereas normally new nurse aides would be required to get all the training and certifications required by the federal regulations within 4 months, that is not required during the public health emergency. The trade organizations have stepped in and offered an 8-hour training, which a lot of new nurse aides have taken and begun working under that. It's important to remember that the CMS, however, did not waive the requirement that facilities make sure that nurse aides are able to demonstrate competency in skills and techniques that are needed to care for residents' needs. But this is a pretty big concern. People are working who've only had 8 hours of training, and you do have to question how effectively nursing homes are checking the competency of new nurse aides when they're already overwhelmed and short-staffed, especially since there really hasn't been a lot of ability for the usual outside protections like the ombudsman or survey agencies to be in facilities to determine whether staff are competent and adequately trained. So this is a pretty significant concern. There has been a push by the nursing home trade organizations to make this waiver of training permanent after the public health emergency ends. And we think that it's important that, while people need to be given time to get the training, that once the public health emergency ends, that people hired under this waiver should get the training that they normally would have received and be given a reasonable amount of time to get it so that they can continue to work, but that they shouldn't be allowed to continue to work without ever having gotten that foundational training that nurse aides would normally be required to get. Some other federal waivers that CMS granted, they waived the deadlines for the MDS assessments so that they no longer have to be done on the same timetable or reported on the same timetable. And they waived some aspects of the PASSER assessment, which is the assessment that's done for new residents who have an intellectual disability or mental illness, to make sure that they are appropriate to be in a nursing facility and that any specialized services they may need are provided. The waiver allows the level 1 assessment to be done after admission instead of before admission as normally. But the nursing facility still has to refer residents who have diagnosed mental illness or intellectual disability to the state PASSER program for the level 2 review within 30 days of admission. Next slide. All right, let's talk about the transfer discharge rule changes. So CMS has waived certain requirements for transfer discharge in response to the crisis. It's important to remember that for most transfers and discharges, all the normal protections are still in place. The transfers and discharges for which the rules have been changed are transfers that are being done for cohorting purposes. So let's just talk about cohorting. Cohorting is defined as the intentional clustering of residents in separate floors or units or wings or even entire buildings with the purpose of trying to prevent cross-infection and avoidable exposure to contagious infection like the COVID-19 virus. So cohorting people who are positive for COVID-19 or who've been diagnosed with COVID-19 in designated wings or separate facilities, which are tailored to meet their needs, treatment needs, and also infection control needs, is a strategy that has been effective in mitigating COVID-19. So this obviously involves the movement of residents out of their rooms, maybe even out of their facility. CMS policy allows and in fact recommends cohorting. And to facilitate this, they waived the requirements around advance notice of transfers, which are done for the purposes of cohorting. So residents are still entitled to a written notice if they are going to be transferred from their facility to another facility for the purpose of cohorting, but it no longer has to be made in advance, 30 days in advance, or in fact, in advance at all. It does have to be done as soon as practicable. So they should get a written notice explaining the transfer, and it should happen as early in the process as practicable. CMS policy also waives the right to appeal these transfers if they are if they're done for the purposes of cohorting. So unlike in normal circumstances, there's no advance written notice. The notice doesn't have to include the appeal rights because there are no appeal rights for these transfers or discharge or transfers. Facilities are allowed to transfer. So specifically, the situations in which this is allowed are facilities are allowed to transfer residents who either have symptoms or a confirmed diagnosis of COVID to another facility that's dedicated to the care of people who have COVID. They're also allowed to transfer residents without symptoms to another facility that's dedicated to preventing them from getting COVID. And then the third situation, they're allowed to transfer people without symptoms to a facility for observation for signs and symptoms of COVID for up to 14 days. The requirement to provide a notice of bed hold policies is also waived in this situation of cohorting. So it's really important to keep in mind that for all non-cohorting related transfers, all the normal protections and requirements still exist. So if a person's being discharged because of non-payment or because they've been smoking in the facility, they still have the right to an advance 30-day notice with all the normal pieces of information being required to be in it, and they have the right to appeal that discharge. Next slide. So cohorting is a really good way to prevent the spread of COVID. But with that said, the moves that are involved in order to make cohorting happen create a huge change in the midst of an already really stressful crisis scenario, and it's traumatic for residents. And it's not a move that residents are allowed to refuse, which makes it still more difficult. Nursing homes are still required to take steps to help residents and their families understand what's going on and understand that the move, with the purposes of it, that it's part of a cohorting plan. They're required to prepare residents as much as possible for the move, to make sure that their belongings go with them, and to give them a choice to whatever extent is possible. And facilities should notify residents of the availability of the long-term care ombudsman for help in understanding their rights and protecting them during a move. I want to also talk about moves within a facility. CMS also waived regulations which would normally allow residents to refuse a room transfer or a change of roommate, but they waived regulations to allow room transfers within a facility where they're done solely for the purpose of cohorting. And that includes waiving the right to share a room with a roommate of your choice. They can change your roommate if it's necessary in order to effectuate cohorting. They don't have to provide the requirement to provide a notice with a rationale for the move, and the resident's right to refuse that transfer to another room are waived during the public health emergency. Unfortunately, involuntary discharges are still permitted during the pandemic. We really advocated with the Department of Health early in the pandemic to prohibit involuntary discharges during the pandemic because we were very concerned about people being involuntarily discharged from nursing homes, maybe even sent to homeless shelters. During the pandemic, we were worried about people being displaced because of COVID, and also people being sent to places that are not safe necessarily, potentially spreading the virus or going to other communal living situations where they might be exposed to the virus. However, the Department of Health declined to do that. And so involuntary discharges continue to be permitted even during the pandemic. Most discharge planning requirements are still in place. And so the facility has to do a safe and appropriate discharge. There is one regulation that was waived, which is that long-term care facilities don't have to assist residents in their residence in selecting a provider using data such as standardized patient assessment data. They don't have to do all the same, or provide all the same information as previously about other facilities that the person might be going to. I want to talk about when people have to leave a facility for cohorting purposes. So ideally, if a resident is transferred due to their COVID-19 status, they should be able to go back to their original facility after the emergency situation has ended. Bed hold rights, unfortunately, have been waived during the emergency, meaning that they don't have the same bed hold right they would normally have to go back to their bed within a certain number of days or to the first available bed in the facility. However, they should be able to return to their facilities under other federal regulations that haven't been waived. And they should be able to go back to their previous room if it's available, or otherwise to the first available bed. Important to remember there is a state regulation that remains in place, which at 28 Pennsylvania Code, section 201.29G, which says that facilities responsible to assure that appropriate arrangements are made for a safe and orderly transfer, and that the resident is transferred to an appropriate place that is capable of meeting the resident's needs. So nursing facilities continue to be responsible for only discharging people to a place that meets their needs. So, and if that means that if they need nursing home level of care, it would not be appropriate to discharge them to a personal care home or a boarding home or a hotel or to a homeless shelter. And it would also not be appropriate to discharge them to their home or to a relative's home if services are not set up that can meet their needs there, or if that place is not accessible to a resident with mobility needs. Another important thing to think about is some residents may choose to want to leave a nursing home. Either just because they want to do that or particularly because of COVID. And nursing home transition services are available through community health choices, but a problem has been that it's not a fast process. It takes a while to apply for home and community-based services, and housing is always a big barrier to anyone who doesn't already have a home to go to. The nursing home transition program will locate housing for people who don't have it, often in subsidized accessible apartments, but there are waiting lists for that housing, and it can take quite a while to do that. The Pennsylvania Health Law Project has been working on advocacy around creating policy solutions to support more expedited nursing home transitions during the pandemic. So, and they will be sharing any policy changes that they're able to achieve. So keep an eye open for that. So we wanted to talk a little bit about a phenomenon that we've been seeing recently in Philadelphia. And we're curious whether people are seeing it in other parts of the state. We've seen a couple of facilities in Philadelphia which are doing what they call right sizing. And what this means is reducing the number of beds and residents that they have in their facilities. Many facilities are experiencing financial problems in the wake of COVID. They're having problems because they're not getting the same volume, anywhere near the same volume of Medicare patients coming in for rehab services, because people are trying to avoid having to be in nursing facilities. And so they're not getting nearly the number of Medicare, which pays much better, patients. At the same time, they have lost residents because of many facilities have lost residents because of COVID, and their expenses have gone up. Although their expenses have gone up around PPE and treating residents who have COVID. They have gotten additional federal funding, but facilities continue to really struggle in the wake of COVID. Somebody's phone, I think, is ringing. And as a result, we're concerned that we're going to begin to see more and more facilities filing for bankruptcy, making it clear that they're experiencing financial problems, and maybe even closing. So in response to this, some facilities are trying to change their business model. And what we've seen recently in a couple of facilities are nursing homes giving up or transferring their Medicaid beds, closing down those Medicaid beds to have fewer Medicaid residents, fewer long-term residents in their facilities. And they are then discharging those residents to other facilities in order to shrink their facility. And presumably they're going to be trying to branch out into other areas besides long-term care instead. This is something that we've seen in a couple of facilities in Philadelphia, where facilities got permission from the Department of Human Services to give up Medicaid beds, and they then discharged residents. It was particularly of concern because the residents got notices that the nursing home tried to characterize these as voluntary discharges, but basically it was presented to the residents that this was happening and they were going to have to leave. And many of them were not given advance notices that made it clear that they could appeal. After the ombudsman brought this up with the Department of Health, I think the facility has been informed that they have to treat these as involuntary discharges, and any further discharges, in any further discharges, the nursing facility has been informed that they're going to have to give involuntary discharges. But we're concerned that nursing facilities may continue to try to treat these as voluntary discharges, and that they are trying to transfer people in the middle of this pandemic. It's really important that the ombudsman be notified when this is happening. It didn't happen initially in Philadelphia. There's been some more communication established between the state ombudsman and the Department of Health around the importance of notifying the ombudsman when these kinds of things are happening, so that the ombudsman can be available to explain people's rights to them, and to help people who want to who want to appeal a discharge. At this point, I'd actually like to see, has anyone seen this, or does anyone have any questions about this? Alyssa, are you able to open it up to that?
Anyone wants to share anything related to anything, we are still getting issues related to other rights, and we'll have questions, but just related to you can unmute yourself.
All right, well, so this may not be happening yet. I mean, it'd be wonderful if it's not happening yet in other parts of the state, but I would really.
Huh? Someone asked how it was discharged. I don't think I'm trying to ask, but the
Sorry,
question, have anything more? Jenna asked the term discharge when the thing.
I'm sorry, I couldn't hear that. Is it in the chat?
Yeah.
Hang on a sec. Oh.
Can you?
I can't. I'm so sorry.
Chat. There's a question.
Okay.
How do they determine who?
Oh, how do they determine who's discharged? Okay, I think the question was, how do they determine who's discharged? That's a really great question, and we don't. There's a lot that we don't know, and we're still trying to find out. We have there is some concern that about whether the facility has selected people who are Medicaid residents. I guess I should say in this particular case, there's still enough Medicaid beds, despite the Medicaid beds being closed, for everyone who's there. But the facility is still transferring residents out, and we're concerned that they may be choosing people who have Medicaid, and we don't really know how they're choosing people. They have said that they are not choosing the most frail residents in order to avoid having to uproot them. But we otherwise don't know, and we are obviously worried about how they're choosing that. And we've got concerns about, what does a safe discharge look like during a pandemic? If a facility wants to discharge these residents, are they sending them to facilities that may have their own COVID outbreaks? Are they facilities that have good infection control practices and are going to provide quality care that is as good a quality as what they were getting where they are? And I think there's still a real question about legally whether facilities are allowed to do this. That they are apparently, of course, they can only discharge people for one of the 6 permissible discharge reasons. And the reason that they are saying they are doing this under is closure of the facility, but they're not closing the facility. They are just downsizing the beds. And if we have residents who want to appeal this, that's something that I'm interested in doing, because I don't think that it actually fits in that permissible reason, because these facilities aren't closing. They're just choosing to have fewer residents and to give up Medicaid beds. So if you do see this, we would really encourage anyone who does see behavior that looks like this to reach out to me. I'd be really interested to hear about it. And we've been doing advocacy with the Department of Health through stakeholder meetings that we've been having, in which we have the ability to raise up issues that we're seeing in nursing facilities to the Department of Health, to advocate for quality of care and for residents' rights. You can also share it with the state ombudsman, who is aware of this phenomenon and concerned about it, and involved with talking with Department of Health about protecting the rights of residents in this situation. All right, next slide. All right, so let's talk about visitation, which is a huge, huge issue during the pandemic. In March, CMS required facilities to restrict visitation of all visitors and non-essential healthcare personnel, except for certain compassionate care situations, such as, but not limited to, end-of-life situations. The term compassionate care has been, the definition of this has been debated a lot. And while end-of-life situations were used as an example of a compassionate care situation, it's not, CMS has made it clear that compassionate care situations do not exclusively, are not limited to end-of-life situations. We'll talk in a couple of slides about more recent definitions they've given that make it clear that it's actually much broader than this and encompasses more situations in which a resident really is in need of contact from loved ones outside the facility. Which can include a person who's suffering from isolation or depression or experiencing a decline. So, people who, so compassionate care visits have been allowed throughout the entire period, although in nursing facilities have, it's been difficult to be able to do it. But other than that, visitation was very much restricted for many months. In May, CMS issued what they called nursing home reopening recommendations, which set out a process for nursing homes to reopen. And that process involved going through 3 different stages and basically required that in order to have any visitation in the facility, there had to be no new cases in the facility for 28 days through 2 14-day stages. They also required that facilities be in a place where they were capable of managing in the event of a COVID outbreak, meaning that they had to be not experiencing any staff shortages, and that they had to have adequate access to testing, and that there had to be local hospital capacity to treat people with COVID. So that policy was in place until this fall. More recently, that has been replaced by a newer current policy. And it's important, let's talk about that policy. It's important because some facilities are still arguing that they can't allow visitors based on the earlier policy, or they're otherwise resisting visitation. Next slide. So the more recent CMS policy permits visitation in certain situations. And it talks in terms of both outdoor visits and indoor visits. Outdoor visits are preferred, and it was particularly the case when it was issued. It was summer, it was warmer weather. Outdoor visits were a really good option, and of course are safer in terms of not spreading the virus. So facilities were encouraged to create accessible, safe outdoor spaces for visitation, like in courtyards or parking lots or under tents or in patios. In order for a facility to be required to do outdoor visitation, the county's positivity rate has to be under 10%. And the guidance does say that a facility's outbreak status can be a consideration, but there's no actual prohibition on doing outdoor visitation based on the facility's status. But again, the county's positivity rate has to be under 10%. For indoor visitation, facilities are required to accommodate and support indoor visitation in certain circumstances. And this includes visits beyond compassionate care situations. And the circumstances in which they're required to allow indoor visitation are these. First, there's been no new onset of a COVID-19 case in the last 14 days, and the facility is not currently conducting outbreak testing. And the county's positivity rate is under 10%. So in other words, there's no new onset of, there's no new case in the last 14 days. There's not an outbreak going on, and the county's positivity rate's under 10%, which is still most of the counties, if not nearly all, in the state. Visitors, there are some sort of overarching requirements in order to permit indoor visitation. Visitors have to adhere to these core principles around masking and washing their hands and social distancing. And staff are required to provide monitoring for anyone to make sure that people are doing that, and to monitor especially anyone who seems to be having difficulty adhering to those requirements. Facilities are recommended by CMS to limit the number of visitors per resident at one time, so that people can be safely social distanced, and to limit the number of visitors in the facility at one time. And so in order to do that, schedules are a good idea to make sure that there aren't large numbers of people coming in at the same time. And facilities are also supposed to limit movement in the facility, to try to get people, to avoid having people unnecessarily walking through parts of the facility that they don't need to be in. Rather, they should go directly to the residents' designated visitation area. And visits for residents who share a room shouldn't be conducted in the residence room. So this is a really big change. We went from all spring and much of the summer having almost no visitation allowed, except for compassionate care visits, to the policy we have in place now permits visitation with these restrictions. Again, for counties where the positivity rate is under 10%, and for indoor visitation, there can't have been a new onset of case in the last 14 days, and they can't be currently experiencing an outbreak. But where that's not happening, facilities should be and are required to be facilitating indoor visitation and allowing that. And even more broadly, outdoor visitation where it's warm enough should be taking place. At the time we put these slides together, this was all feeling a lot more like something that was going to be happening more and more, and it really should. Now that COVID cases have begun to rapidly increase, this will probably start to change the game a little bit. In Philadelphia, I heard yesterday that the positivity rate is now 13 or 14%. And so if counties begin to have higher positivity rates, and as facilities unfortunately begin to have new onset of cases, that is going to make visitation more difficult again. But I would really encourage everyone to, in situations where visitation is not just permitted but required to be allowed, to advocate for residents to be able to have those visits. The Department of Health has indicated that they don't have a way of monitoring whether facilities are complying with this policy or not, except to the extent that they are checking when they go in to do surveys. However, if people who are denied visitation can make a complaint to the Department of Health, and the department will investigate that and will cite facilities which are not permitting visitation, which they are required to provide under the CMS policy. Next slide. Few other things about the current visitation policy. The CMS guidance states that what visitation looks like can vary from facility to facility based on what the facility's structure is and the residents' needs. So in terms of whether it can be in residents' rooms, or whether facilities may have dedicated visitation spaces, whether a lot of visitation can happen out of doors. And it's important to remember that, well, the guidance has as an overarching principle that in any in all situations where visitation is occurring, there are core principles that facilities have to adhere to and that have to happen with visitation, which are screening before people come in, hand hygiene being required, social distancing taking place during visits, PPE being used, including masks, of course, for both staff and residents and visitors, and that cleaning, especially of high-touch surfaces, and disinfecting be taking place regularly, and that facilities be complying with requirements around testing and cohorting. So all of these basic safety practices have to be in place in order for visitation to occur. And facilities have a requirement to do all of these things. And so these things should be happening so that visitation can happen. The guidance also says that visitation should be person-centered, meaning that it should happen in a way that considers the residents' physical, mental, and psychosocial well-being and supports their quality of life. It also notes that one way to reduce the risk of transmission is to use physical barriers like plexiglass dividers or curtains. And it also says that facilities should facilitate visits so that they can happen with an adequate degree of privacy. Next slide. And I just wanted to circle back to compassionate care visits, which have been allowed throughout the pandemic period and continue to be allowed regardless of what's happening in terms of the county's positivity rate or whether there are COVID cases in the facility. Facility is required to permit these visits. It does not refer exclusively to end-of-life situations. The CMS has made that clear in a couple of their policy guidance statements. The most recent guidance has additional examples of where compassionate care visits would be appropriate, but they make it clear that this is not an exclusive list. So similar kinds of situations would also be appropriate for compassionate care. So the examples they give are a resident who was living with their family before being recently admitted is struggling to adjust to the change in environment and with not seeing their family. That resident may need a compassionate care visit. A second one is a resident is grieving after the loss of a friend or family member who's passed away, and they need the support of seeing a loved one. That would be appropriate for a compassionate care visit. Another example is a resident who needs cueing and encouragement with eating or drinking, which was previously provided by a family member or another caregiver. And they're experiencing weight loss or dehydration or some other adverse effect from not getting that assistance. That would be another situation where a compassionate care visit would be appropriate. And then the last example given in the guidance is a resident who previously was used to talk and was more interactive, is now experiencing emotional distress or is speaking more seldom or crying more frequently, is clearly struggling emotionally or has had a cognitive decline. That person also may need a compassionate care visit. And facilities are required to allow visits in those circumstances. And again, if facilities aren't, the Department of Health is available to enforce that, and has said that they are committed to, or they're interested in making sure that this happens. Next slide. It's important just finally to note that most residents' rights are still in place. Residents still have the right to receive quality care. They've got the right to be fully informed about what's going on about their care, about their medical condition. They have the right to participate in care planning, and of course to be free from abuse or neglect or exploitation or misappropriation of their property. And they have the right to complain or to voice grievances. So all of these rights are still in place, but we're really in uncharted territory during the pandemic with how these rights can be exercised and how they may look different. given the difficulty for residents in accessing people to tell about what's happening, and the difficulty for outside advocates like the ombudsman to be able to be present in facilities to know what's going on. And facilities are being impacted by COVID, and that's without doubt resulting in staff shortages, which is affecting the quality of care. So there's a lot of reason to be concerned that facilities may not be fully in compliance with all of the regulations during the pandemic. So it's really important that all of us be on the alert and be prepared to advocate for residents' rights despite the pandemic. Next slide. Alyssa, do we want to go to questions?
One more slide. The territory.
Hang on. I'm sorry, what was that, Alyssa?
There's one more slide.
Oh, sorry about that. Sorry about that. Oh, there is one more slide. I'm so sorry. As I said, this really is new and uncharted territory. And so it's really important to be vigilant and pressing for residents' rights to be protected. But some things that we need to we can't help but ask include a resident's right to be fully informed. What does it extend to during this pandemic? Normally it would include the right to be, aware of, to receive information about their condition and their care plan. But here, does it cover the right to be fully informed about their COVID status, the status of their roommates, staff, and other residents in the facility, and the rights of the family to know about the COVID status of the facility? And we know residents have the right to quality of care, but how's that being measured, and how's it being impacted during COVID? Residents have the right to person-centered service planning. During COVID, is person-centered service planning addressing the new COVID-specific issues that are facing residents? Facilities, for instance, our facilities should be incorporating specifics about things that are facing residents because of COVID, like isolation, how to address that, how to foster and facilitate connections to family, like how are they going to have visits either in person or through technology, how to help with technology, what activities to offer, given that some activities can't take place because of the restrictions. All of that is sort of are new elements that should be part of person-centered service care planning. And then about residents' rights to be free from abuse, neglect, and exploitation. Big question about who's watching, who actually can tell what's happening, who's reporting, who can get into the facility, how is it being evaluated. Until recently, surveyors were only entering nursing homes for infection control complaints or immediate jeopardy complaints. But now they're back to doing more regular surveying. So there should now be more eyes on the facility. And hopefully the ombudsman will be able to start getting back into facilities. But as case numbers are spiking, of course, there are concerns about whether ombudsmen will be able to get back in facilities, and will we see another rollback in surveys. Thank you. For people who aren't long-term care ombudsmen, please turn to your local long-term care ombudsman program for assistance for residents. To those of you who are ombudsmen, thank you for the very, very hard work you're doing in this situation, which is so important. My contact information is on the last screen, and you can always contact me if there's any assistance we can provide or questions we can try to answer. So thank you.
All right. You able to?
It's a little choppy.
Okay, so let's ask questions in person. I don't think I'm going to be able to.
Yeah, I can see the questions in the chat. Do you want me to just read them?
You got to. So, want to question? Lori, how about you start with yours?
Hi, everybody. So my question, Pam, in the chat was how, and this is, I guess, for everybody on the call as well as Pam, how helpful has the Department of Health been when we are filing complaints regarding compassionate care visits? Are they tending to respond more conservative in that they're leaning towards allowing the facility to be more restrictive in an effort to keep everyone safe, or are they responding more person-centered or resident right directed?
This sounds like a really good question for the group, since they will really have been the ones who are in contact with a lot of residents to do that. Can we throw that open to the group? Are people able to respond? Alyssa, are we able to unmute people?
People can unmute if anyone has DOH has been. If they've tried to contact them.
I do know that I got an email from an ombudsman who was having problems getting a facility to allow compassionate care visits. She pushed back, and the facility is now going to do that, not very happily. I don't know that she had to contact the Department of Health, but I think she did push back with, by explaining that the policy requires it and that it was that that particular resident met the criteria for it.
The guidance on what the can you hear me?
I'm sorry, was somebody else besides Alyssa trying to speak?
Me.
I'm so sorry about the sound.
I think it's because my computer is recording.
Ah, that might be it.
Pamela, it was me that I emailed you about the compassionate care visit.
Hi.
Hi, and thank you.
Talk about your experience. Yeah, go ahead.
Yeah, so I've been working for a couple months to get this resolved, and there was questions on the definition between CMS and DOH rules. And then it was clarified, the facility no longer has COVID, and they're still denying a compassionate care visit based on the 10%, if the county goes above 10%.
They're still saying that now?
And the son will not be allowed to, go ahead, what?
No, you go ahead.
You had a question? So the son will not be allowed to take his father, stand him up, walk him around, or give him water. He won't be allowed to go near him. Is that accurate?
My reading of the federal guidance, which is what the department is directing facilities to comply with, is that social distancing has to be in place, including for compassionate care visits.
So then what's the difference between an indoor visit and a compassionate care visit then? What would be the purpose of calling it a compassionate care visit if you're not providing comfort, nutrition, physical therapy?
I think that the difference in the federal guidance is simply that it's more broadly allowed. It's allowed in circumstances where other visits are not allowed. And I think the nursing home is wrong in saying that they can deny a compassionate care visit because of the county's positivity rate or because of cases in the facility. I think the guidance is clear that compassionate care visits are required to be allowed regardless of those things going on. So I think that's the difference, is that they're allowed basically all the time.
I see. Thank you.
Yeah, the state had, confusingly, the state had issued guidance, state guidance at the beginning of September that would have created sort of an essential caregiver exception. where it would have allowed some caregiving to take place. Unfortunately, they repealed that when the federal guidance came out and instead directed nursing homes to comply with that. So that's an area for where a lot more advocacy is needed to try to get the ability to do what your resident son wants to do, to be able to actually provide some hands-on care. Let's see. Is there another
question? Gloria? Do you want to unmute yourself and ask your question?
I'm actually going to post it because it's kind of long.
Okay. Any question they want to unmute? We will stay past 11:30. So
Yeah.
we have time. There were a lot of questions.
Let's see. While we're waiting for that one, I can see if there are other ones. Let's see, here's a comment or a question from Bernadette Jones. Upon admission to the skilled nursing facility, a resident is quarantined to their room. As a result, the resident doesn't receive the full benefit of rehab, physical therapy, and occupational therapies ordered because they are unable to utilize the therapy room and the equipment that is available in the room. As a result, their progress is slower. On day 21 of their stay, they receive a notice of non-payment. Is there a specific billing code that covers the bill for the time they are in quarantine due to COVID? That's a great question that I can try to get an answer to. It sounds like this is partly a Medicare question in terms of Medicare coverage, and there have been some changes to Medicare billing and eligibility around COVID. So Bernadette, if you want to get in touch with me after the webinar, I can try to get an answer to that question. Sorry that I don't know it right now. Let's see. Okay, let's see. I'm looking at Gloria from Jean. How does preventing residents from leaving their rooms, the facility, et cetera, during COVID-19 jive with the definition of physical restraint? I know I was thinking about that as I went through the review, and I was saying that isolating someone in their room can constitute a physical restraint. I think that the answer is that it may be partly what the intent of it is. When the intent is to prevent the spread of the virus, it would not be considered a restraint. However, I think the facility has an obligation to reduce as much as possible the extent to which people are stuck or are prevented from leaving their rooms, and to meet their isolation related needs while they're in their rooms. It's a really good question. I think the difference is that the intent is not to restrain them, but rather to protect them, and that some of these limitations on movement are permitted during as part of cohorting, basically, to keep people from passing the virus to each other. It looks like for Gloria's question, I need to download it. Gloria, I'm not seeing your question. It's showing up as a download.
This is Gloria. I unmuted. I actually sent it to you in an email, and it's kind of long, so it won't let me copy and paste it. So,
sorry.
I'll just say it. So from my understanding, state and local governments must comply with Title II of the ADA, and in the emergency and disaster related programs. So under the ADA Emergency Management Plan, it says that programs must ensure that communication barriers do not deny access to people with disabilities. Programs are required to establish policies and procedures to provide auxiliary aids and services that are needed to effectively communicate with people with disabilities, giving the primary consideration of the auxiliary aids to the request of the person with the disability. And so what I wanted to give that background. And we all know that back in July, DOH provided guidance based on a decision by the Office of Civil Rights that a person with a cognitive or a visual or hearing impairment could have somebody in the hospital with them. And so my question is the reality is that a lot of our nursing home residents are going in and out of the hospital for one thing or another, that the nursing home residents have these same disabilities. And why are we not seeing some kind of guidance like this that would allow that one person or designated family members to assist our nursing home residents who have cognitive, intellectual, communication barriers from being there? Because typically they relied on those family members to be there and make those decisions. Like you were saying, they were the ones that would give the nod for care. And this is why those residents are declining, because they don't have that support there that they're accustomed to. So I guess my question is, I feel like disability rights of nursing home residents and, well, long-term residents in general are being violated, but we've allowed it for hospital to have an attendant there. Why are we not allowing a nursing home attendant?
And so the attendant in the hospital was there to communicate between the patient and the medical staff?
Yes.
Okay. I think that's a really great question, and I apologize that I think I missed your email previously. I think this would be a great issue for us to bring to the Disability Rights PA, which has expertise in the ADA, to talk with them about. Would you be okay with us talking afterwards to do that?
Absolutely. I can give you a little background. We actually had Kelly Darr involved in one of our meetings, and she feels that pretty much every nursing home resident is disabled. But I also know that from working with Kelly, they kind of are doing it on a one-to-one basis. And so I wanted to put this out into the group forum that if we are seeing this, to recognize the fact that our residents, not only the nursing home rights that we look at under the omnibus budget and the Rehab Act, but under the ADA, there's a lot of nursing home resident rights that are being violated. And that communication with families is really essential for them. So.
Absolutely. Yeah. So, residents can have the right to make decisions, and their families can have the right to help them do that. But if they can't have access or the technology they need to actually do that communication, then it's really meaningless. The ADA not being so much my area, I would really love to talk with you more about this and to talk with Kelly about this and how we could use ADA arguments for nursing home residents more broadly.
Sounds good.
So thank you for that.
Questions? Anyone else? Question here?
All right, well, Liz, is that all the questions?
Yes, I think.
Okay. Thank you everybody for joining us, and thank you for everything you're doing. And I apologize for the problems with the audio. We do have this recorded, so we'll make it available to people who may want to watch it after this as well. And we'll send it out. Will the slides be made available? Yes, we will send the slides out to all participants. All right.
Thank you.
All right. Thank you, everyone.